Hi, I'm Gladys Young. I'm the Senior Legal Officer responsible for CARICOM Single Market and Economy Matters at the Caribbean Community Secretariat. I will be speaking about the CARICOM Single Market and significant developments in community law. The CARICOM Single Market is a way in which the heads of government of the Caribbean community have sought to create a single space by which community nationals can move and create opportunities for economic growth and development. How is this done? There are 5 freedoms that we would like to refer to them as that are part of this CARICOM Single Market. These are the right of establishment, the movement of service providers, the movement of skilled nationals, movement of goods, and the movement of capital. In addition to the rights that are set out in the treaty itself, there have been decisions of the Conference of Heads of Government and the Council on Trade and Economic Development, as well as other organs of the community, that have created further rights and obligations for community nationals. One such decision is a decision taken by the heads of government in 2007 that created a right of entry for all community nationals, as well as a definite stay for 6 months. Of course, that right of entry is subject to a member state determining that a person is undesirable or is likely to become a charge on the public purse. Given that the heads of government have sought to create this single space, it is also important to ensure that the member states adhere to their obligations and do not put up barriers to trade that have been removed by the provisions in the revised treaty. Additionally, it is also important to ensure that the community nationals do not take particular actions in relation to unfair trading practices or unfair competitive practices to remove what has been created by the single space. In order to do this, the heads, in their wisdom, created the CARICOM Competition Commission and the Caribbean Court of Justice. These 2 institutions play an important role in ensuring the protection of rights, the protection of competition, and the enforcement of obligations. In addition, there is a CARICOM complaints procedure that provides an avenue for community nationals to seek to resolve difficulties encountered. One of the important functions of the CARICOM Competition Commission is to enforce the rules of competition and also to investigate any sort of anti-competitive conduct carried out by businesses. Significant differences between the earlier arrangements and what is contained in the revised treaty is the creation of the Caribbean Court of Justice. That court is unique in international law in that it serves a dual function. It is a final court of appeal for some member states of the community, and it is also the court that will address the interpretation and application of the revised treaty as it relates to disputes between member states and the community, as well as disputes between a person of the community and a member state. Additionally, it is a court that will deal with the interpretation and application of the revised treaty as it relates to the questions referred to it by a national court. The court also can provide advisory opinions in relation to the interpretation and application of the treaty, and those advisory opinions can be requested by a member state or by the community. There have been a number of cases in which a court has had to interpret and apply the revised treaty. Some of the most important pronouncements by the court have been as follows. A person belonging to a member state can bring a claim against that member state. Decisions of member states, the community, and the CARICOM Competition Commission are subject to judicial review. The court can award damages for a serious breach of the treaty where there is a substantial loss and the loss is related to that breach. And also, where there is room in the law of the member state, a member state can implement a decision administratively. One landmark case that merits further mention is that of Shanique Myrie against Barbados. That is a landmark case for many reasons. 1, it was the first case in which an individual brought a claim against a member state. 2, it's the first case in which a member state intervened in a matter. And 3, it's also the first case in which a community made submissions in a matter in which it was not a party to the proceedings. That case was about the right of entry decision taken by the heads of government in 2007. That decision conferred a right on CARICOM nationals to enter and get an automatic stay of 6 months, except for where they were deemed to be undesirable or likely to be a charge on the public purse. As it relates to undesirable, the court would have said that the person would have to pose a genuine, present, and sufficiently serious threat to a fundamental interest of the society. The court also gave guidance as to the criteria to assess that threat. As it relates to the charge on the public purse, the court would have also given guidance in relation to that and would have set out the fact that CARICOM nationals must have a return ticket and the fact that CARICOM nationals only have to have funds for the length of stay as signified by the return ticket. The community is represented by the Secretariat in all matters before the court. The community's role in this case was an important one. In addition to providing the documentation that the community has in terms of the decision and subsequent decisions of the conference, the community would have also made submissions as to the criteria that should be taken into account to assess undesirable, as well as to assess likely to become a charge on the public purse. The community's role is not to take sides in any case of this nature, but simply to provide clarification and assist the court in its interpretation and application of the revised treaty. I hope that this presentation has sparked your interest to investigate further. You can find a wealth of information online, including the actual recordings of the proceedings by the court, as well as executive summaries of their judgments and the full judgments.